Okay, good morning, everybody. This is the South Coast AQMD Hearing Board. Today, we are going to have our general meeting, which is normally subjects that we have discussed not only with each other, but concerns that we have had since the last general meeting. And to our greatest desire is to make our meetings, our hearings much more efficient, as well as timely, and that they are conducted with the utmost care as far as our rules and regulations are concerned, and that sometimes those rules and regulations may have become a little bit obsolete. And so we have had the good fortune of our legal member, Mr. Pearman, go through them, and he has made a very nice I would say, overview as well as corrections to several of them to make them up to date, to bring them up to date. So with that, before we actually do begin, I'd like to introduce not only ourselves, and I'll start with Mr. Balagopalan.
Mohan Balagopalan, engineering member.
Robert Pearman, attorney, member, vice chair.
Mr. Lee. Mr. Ali.
Makai Ali, public member.
Dr. Abraham, physician member.
And I'm Cynthia Verdugo Peralta. I'm the public member and I'm also the chair. And I'd like to introduce people that we have in the audience today, starting with Ms. Conager-Macklin.
Adrian Conager-Macklin, attorney alternate.
Good morning, Madam Chair. Dale Larson, outside counsel for the hearing board.
Thank you.
Good morning, Steve Samaniego, public alternate.
Good morning. I'm Catherine Roberts, Senior Deputy District Counsel with the Office of General Counsel.
Thank you. Okay, what we're going to do is ask for any comments in reference to, if you've had an opportunity to take a look at the draft copy that we have in front of us in reference to what rules we are taking a look at, a hard look at, that Mr. Pearman brought to our attention and has suggested any changes. And if anyone in the audience does have a concern with any of them, if you can let us know at this point so that we can go ahead and address it while we are going through them.
So Madam Chair, so we're doing public comment.
Yes.
And if they have a concern, they're going to address it via public comment, period.
Yes.
Okay, thank you.
And the reason we're taking it forward or ahead of time, because we normally do it at the end, is because of the fact that we want to know if there are any concerns when we come to that item, that we can go ahead and include that concern. You had a comment, Madam Clerk?
Yes, I do. Just wanted to mention that I should have updated page 8-1. The time should have been changed to beginning at 9:30.
Okay, on the first paragraph. Got it. Okay. And is there any public comment at this point? Okay. If not, if you don't mind, Mr. Perino, I'm going to go ahead and turn it over to you since you wrote those.
Okay. And the plan was just to, these proposed changes were largely discussed on October 18th. One section of rules was kind of newly revised afterwards by Mr. Larson and our attorney alternate. So I'll just flip through these quickly. If any of the board members or alternates have a comment, feel free. Otherwise, it should be hopefully non-controversial, and anything that requires some discussion, we can put that at the end just to move things along. So I'm referring to the red line version, and you'll see first that Rule 2A, that was simply a change to bring us into the modern era of electronic filings. Next was in Rule 4B1, and this was actually something not discussed before, but at times, because the existing language about the consent calendar going first, it would seem to limit our ability to move that around depending on the circumstances. You know, suppose that another hearing was on the agenda and those people had to leave early, why would we have to put the consent first. Let's accommodate them with the witnesses. So this just gives the flexibility to certainly want to try and be fair to everybody in terms of how we set consent calendar items on a particular day. The next one will maybe move to the end, which is the additional language in 4C about procedures for placing a case on consent calendar. And when that comes up, we'll refer to the people who helped draft that, Mr. Lawson, Mr. Aiton, colleague, and Macklin. The next change would have been at 8. On page 8-3, Rule 8J, again, just some clarifying language about the continuances, including to make it clear that if need be, not just the hearing board, but in advance, the chair could, for good reason, continue a hearing, because that came up as a disputed matter once upon a time. Next would be at page 8.4 on the Rule 8L, and again, just some kind of clarifying changes, including the ones we discussed about making the recording of the pre-hearing conference a bit optional and trying to make those more flexible and something the parties will more likely be willing to utilize. Next one was at Rule 9A, just again, a simple change, a common sense change in terms of the subpoena time period, and also again, allowing email or even facsimile request. The next one at new Rule 9C, where again, we discussed it in the past that prior language only allowed evidence upon declaration if the party declarant would not appear at the hearing. This designed to make it more efficient that we could use declaration in advance as long as the witness was available for some cross-examination at the hearing. And we've been using those to some great, I think, effect and benefit since then. And that really is the only changes that were made of note. And again, they all reflected what we discussed before, except the one additional to give us more flexibility in the consent calendar order. And then the next item is just at 4.3, which is the consent calendar operations. And as you know, we had some discussion before about formalizing a procedure for consent calendar items, how that material gets distributed to the board and to the public, and when the decision is made to go consent or not, and how people are informed. And so this is the language that I think Mr. Lawson had drafted to that point. So that's the end of my presentation. And does anyone have any questions about the consent calendar procedures, perhaps, as we did not discuss that before? I'd open it up for your discussion.
Mr. Ali.
Right, so essentially, Madam Chair, we're codifying a process that currently exists, as opposed to looking at the language for which it previously existed for consent, where the matter will come before the board irrespective. It just seems to be a lot of communication back and forth with the new language, and it raises a bit of a concern. So perhaps if someone can shed some light on the new language, which is the current process.
Is there a particular number on here that you want to discuss?
Well, the entire, all of the new language, because the way in which the provision reads today is if there's a concern, that concern is brought up before the meeting or on the floor. A lot of this now is back and forth between the hearing board member and the clerk's office, facilitating information that then later becomes either in an email sent or becomes a part of an exhibit. But all of that should take place in the light of day, not after the fact.
I think this is just memorializing what is the current procedure to a large extent. It's just laying out quite clearly, because I've mistakes in the past of sending a reply not just to the clerk, but to other parties, the petitioner, the respondent, or even to fellow board members. So this states don't, clearly states don't do that. Just everything goes through the clerk, and the clerk will forward it to the affected parties, and they will get back to the clerk, and the clerk gets back to the board member. At the end of the day, then if we provide consent or not or no consent by the due date, then it's done. I think that's just You're right. It's identifying the process we are currently flowing, but I think it's lays out quite clearly what is not to do or what should be done. Because frankly, I had some problem before where I thought I gave consent, but I thought I had the ability to change it during the hearing, during deliberation, or when we hear public testimony that change what you might have agreed upon. I think there's language now here saying that okay, then which I think may need to be looked at. Number 6 and number 10 is I think it's identical, or maybe we can clarify. I think number 10 seems more appropriate because, that if a member or members get new evidence, during the hearing, then they can, even though they're previously given consent, they say, okay, that changes my thinking. We should have a scheduled hearing later. And it has happened before. We had on the day of the hearing, a couple of memos, documentation that was provided, that was not provided before we granted consent. And so so I thought this clearly outlines what procedure we have to follow. And, so there's no ambiguity, on that.
Correct me if I'm wrong, Mr. Ali, but I think what Mr. Ali was saying is that that there shouldn't be any back and forth of emails, even if it's facilitated through the clerk's office, that you would rather see it happen at the hearing. Is that correct, Mr.
Correct.
Ali?
Like, to be honest, I don't even understand why there's procedures being placed here. The discussion is number 4. So this is almost like redundancy. We didn't particularly need a process laid out. The process, in my opinion, raises tremendous amount of concern with respect to the potentiality of a daisy chain or serial meetings transpiring through the clerk's office. So just look at number 4. At any time prior to the submission of the case, the hearing board shall immediately remove a matter from the consent calendar upon the written or oral request of the respondent or the petitioner or any hearing board member. That means the item is then agendized. Then if a member would like to remove it, then you need to state your case either in writing or orally. Shall hear the matter on the scheduled hearing date or shall assign the matter to the next hearing while fully complying with notices, et cetera, et cetera. So you got 4, then you have 5C. So our current rules just needs to be followed. You publish the item, you agendize it pursuant to the Health and Safety Code and or Brown Act, both, prayerfully. And if a member has a concern, then they bring that concern either in writing or orally. But to codify a process, this process, in my opinion, facilitates the violation of the Brown Act.
Did you want to speak to that, Mr.?
Dale or Adrian?
Okay, Dale.
Sure, I'd be happy to jump in. So what we were tasked with trying to do here was to maintain, we heard from at least one member of the public as well at the October meeting saying the consent calendar is a valuable tool if it can be used properly because it promotes efficiency and doesn't require the parties to always show up, which costs a lot of attorney time, attorney money to the parties. And so we were tasked with maintaining the ability to use the consent calendar in an efficient way that's also Brown Act compliant. And so I disagree a little bit with saying that all this does is codify the existing procedure, because this is meant to really tighten up and make sure that there are not any cracks that would lead to a Brown Act violation in this process. And the way it does that specifically is because one board member has the right to remove something from the consent calendar. We wanted to build a process by which you all, the members of the board, could obtain information to guide you in that decision whether to remove something from the consent calendar or not. But none of that information can ever be shared with any other board members, because then that could result in a serial meeting. So this was meant to codify the ability to obtain information from the parties so you can make a decision whether something should remain on the consent calendar or come off of it. Make that decision before the meeting occurs. But your colleagues, the other members of the board, don't know any of that until the public also receives the same information, either in the agenda packet, or if it's within 72 hours of the meeting, which it shouldn't be, it would be made available to the public at the same time it's made available to the board. So the attempt is to allow the members to continue to use the consent calendar in an efficient way, while also closing up any potential cracks here or any ways that this could lead to a serial meeting by codifying very clearly the steps that the board members and that the clerk must take, so that the public learns of anything at the same time that other members would.
Yeah, Madam Chair, my concern is if, go back to number 4. Number 4 is very clear. So if I'm Joe Schmo, public guy, and I come before the hearing board and I want a matter to be removed, watch this. If prior to the submission of the case, comma, a member of the public requested the removal of a matter from the consent calendar, the hearing board shall consider the reasons for the request and shall, another mandate, vote on the request prior to proceeding with the item on consent. So the public has a different process than the hearing board member. I have to then hear the public's petition. They proffer their petition. I then consider that. Then I vote if I want to proceed forward or not. For a hearing board member, I follow this seemingly labyrinth of a process where they're sending emails back and forth to the clerk and all over the building, et cetera. Then you can pull it or you can allow it to stay. It seems as if there's an inequity and a double standard for the public versus the hearing board. If the hearing board member is desirous of removing an item, they ought to come to the meeting, as is the case for the public, state their claim, it's voted up or down, and then the matter proceeds, which is pretty much what it reads here. It reads, if you have a concern, you bring your concern orally to the floor, allow there to be deliberation. That's what we currently have, and that's the process. The rest of the stuff in red is superfluous.
Let me just say one thing, because what I'm hearing from you, Mr. Ali, I don't want to argue the point, but I just am thinking about how we do it. And when we have a body, a person from the board who has a question on whatever item it is, they have the ability at that point to send their questions to the clerk, right? And then that clerk sends it out to whoever it's intended to, who can possibly answer that. If we didn't do it that way, then all parties would have to appear. And they would, though, because how else could we pull it? We wouldn't be able to pull it unless we were all here. And so what they're trying, and correct me if I'm wrong, trying to eliminate the mandatory presence of both parties. And if you can eliminate it through the consent calendar, then, and you're still getting your questions answered and the information is disseminated to us, and I'm hearing at the same time it is to the public, then I don't understand what the problem would be
Right,
at
but
that point.
Why don't we just read our rule? Can we, attorney, can you read rule 4? Remember, I'm not saying anything. I'm not giving an opinion. I'm reading what the rule says. So our rule says exactly what I just stated. Our rule states, at any time prior to the submission of the case, the hearing board shall immediately remove an item from the consent calendar upon the written or request, upon the written or oral request of the respondent or the petitioner or any hearing board member, and shall hear the matter on the scheduled hearing date or shall assign the matter, etc. But this, it says written or oral request. It doesn't say, how do you then codify a process when the rule already says oral or written? That means the item has been sunshined. The hearing board member then brings forth their concern. You don't have to have the parties here. But if somebody wants to pull an item forward, we then vote and say, no, we don't believe that's a valid request, and off the matter proceeds. If we believe the request is valid, then the matter is scheduled for another day for a hearing. But that's what it currently says. This is not my opinion. This is what's written. Unless there's an interpretation of what is currently written, I'd like to hear that.
I don't see a conflict between the proposed new procedure, which is generally geared towards the written request to move it off the consent calendar. It doesn't prevent any member from making an oral request. When that time comes, they could say, no, I have an issue. And if at that point, the board would then, because the parties wouldn't be there because they would have thought it's a consent, the board would be required to reschedule it for a separate time. but certainly the board member can still make that oral request, or any member of the public can come in and say, I disagree with this being on consent, and the board would consider that request. It would have to reschedule it because the parties wouldn't be there.
True, but I don't want to give a hearing board member that level of power. My concern is one person can pull the matter off the agenda when that's not what this says. What this says in number 4 is that they have to bring the matter in writing or orally. This new procedure allows for a hearing board member to hold up the consent calendar, which has historically been the case, hold up the consent calendar back and forth with all of these questions when the board ought to decide if the matter should proceed forward or not. If there's already a stipulated agreement, right, and the parties have already opined therein, then why would a board member hold it up? We can vote if we want to allow that member's point to remain, or we move forward.
So
It's the
that's,
same way for the public.
so that sounds like a concern with just generally the idea of giving one board member the power to move something off consent, as opposed to these sort of new procedures, which
Right.
facilitate that process.
So the new procedure helps to facilitate gridlock, and the way in which it currently reads, for the public, we have to vote for the public. Then let's vote for the hearing board member.
Dr. Abraham.
My concern with that is that protecting the rights of that one individual hearing board member, that's a minority maybe position or opinion, but the fact that a concern was raised makes me feel that it should be adjudicated or deliberated further and in public, and that is the right of the minority member. Because I feel like what ends up happening otherwise is it will always be railroaded to move to consent, and conversation or discussion or dissent is always voted against, because it may always be a minority or a single member that raises the concern that makes it come off of calendar. So if we're all voting always for consent, but a concern comes up, we will never bring an issue forward to the public unless I guess they make good arguments. But how would you even do all of those pieces? I don't know.
But read the rule, my friend. It's that way for the public.
I get the rule. I'm just saying the spirit of how do you, with parliamentary procedure, protect the rights of minority opinions
But we don't
on
adhere
a
to
governing
parliamentary
board.
procedure. We don't adhere to parliamentary procedure.
Well, okay, so, but I believe that the effort in writing all of this was to tighten it up and make sure that there was no possibility of a serial meeting. And I have no problem with doing that. I think that the way that it's laid out is plain enough, not only for the board members to understand, but also the public to understand that our efforts are indeed to try and be as, what's the word I want? To be as open to the public and to be as transparent to the public as possible. And if that even makes it, that's another hoop that we need to jump through, I don't have a problem with that.
So can somebody interpret 4 for me?
Okay, so I see two different things here. One, members of the public don't generally comply with the Brown Act. It is the members of the board who have to comply. So members of the public can have a distinct and separate process from members of the board, because we would have to have a majority vote in order to do what you're suggesting. Otherwise, one member, if these rules allow, can put it on or pull it off of the consent calendar, which means it's then agendized and it proceeds it so it's a normal matter. But absent that, you're still going to have a meeting, which defeats the purpose of the consent calendar.
Mr. Pearman.
Yeah, I agree with their comments. There's nothing inconsistent with 5 and 4. 4 still, we're not changing 4. So a hearing board member can just pull it, boom, even orally. It doesn't have to be in writing if they don't want to. The whole point of 5 is to give us a little more flexibility, that if the only reason someone wanted to pull it was because they had one question, they might get that question answered in advance, which then would allow to go consent calendar. And the whole point is to make sure that if they do that process, they satisfy the Brown Act in doing that. So I think it makes sense. And again, it doesn't detract from 4. I think as the attorney ultimately said, there is logic to have a slightly different process for the hearing board versus the public in these actions. So I support the concept.
And if I may, just one more comment. The board itself, when we answer the questions, it needs to be really clear. You do not circulate or respond, reply all, or anything of that nature. Because then I think it does go back to a violation of the Brown Act, and you would have a serial meeting or a daisy chain meeting or whatever it is. So I think that has to be clear. The responses can come out and go out to everybody, but there is no reply. And I think we get tripped up sometimes when everybody wants to reply all. That shouldn't happen.
Can I ask a clarifying question about that one? So then if the board members are able to see at least that information, whatever the question was in the responses, does the public ever get to see that? And they can say, we are asking the board to pull this off of consent calendar, right? That would be the right of the public.
Yeah, but the concern is members of the board should not see communication between members of the board. They should not see Mr. Balakapalan responses. He should not, because then now I'm able to form an opinion. That's the element of the Brown Act. No, but
That's what I said.
right now, I'm with you. But no, but you're saying reply to all.
No, you cannot reply. In other words, Ms. Peralta's response is solely hers. And the way you get around having a reply all, or having people go back and forth, or seeing or being privy to somebody else's comments, is you send it to one person at a time. You don't send it to everybody in a group text.
Right, and and my argument is nobody should see anybody's reply at all until you get to the meeting and it's an exhibit.
And that's fine.
Right, there should not be any, because now therein lies the Brown Act issue.
Well, when you say you show up to the meeting and an exhibit, the way this is contemplated is that it would be an exhibit attached to the agenda 72 hours in advance.
Yes, but in some instances, the responses are sent to the entire board.
That cannot happen.
Right,
And this
happens.
is geared to clean that up.
Okay, so just so we're clear, just because I'm not new to this.
No,
right?
exactly.
Okay, I'm not new to this, so I want to make sure that in the way in which you've been doing it, that process has to stop. Now, I still want to register my objections to this completely because we already have a rule. I think, again, I don't particularly believe that one will enable any aspect to the other. You're just simply codifying a process. You're not necessarily amending what my concern is. And my concern is that one member can essentially stop matters from coming. If I'm a business owner in the basin, and I've worked closely with the legal counsel of the AQMD to reach a stipulated judgment or a stipulated agreement, that then is thwarted because of questions back and forth. Small business folks can't afford to hire lawyers and what have you. So again, in my opinion, one does not necessarily impact the other. They're not even at all connected. One is simply cleaning up a process that I brought forward with respect to the way in which consent matters are being dealt with. But I'll still hang my hat on the fact that I believe that we as a board ought to be able to have the right to vote, which is the case in any other body. As a Brown Act body, they can outvote anyone on the panel in order to move an item forward.
Mr. Pearman, did you have anything else?
My suggestion was maybe we can vote on the other rules, pull this one out, because I think Mohan might have a change or two he might think about, and I might too. And I know Ms. Alisa Lee might vote against it anyway, so that way we can have it separately. So I would suggest let's conclude this discussion, vote on just all the other rules, then have this one dealt with separately.
Okay,
Actually, I now that I looked at it carefully, 6 and 10 are separate. 6 gives so I take that back, because I think that clarifies it in my mind. Oh, you have a comment? Yeah. So because I think 6 is basically saying to let the clerk know whether you agree to be in consent or not, and the issue, and I think I've done that where I've been the sole board member saying I'm pulling it out of consent. And I don't think we even have to give a reason previously, but I gave a list of 10 reasons why and it was pulled out of consent and we had the actual hearing. So it does give the board member the right to pull a matter out of consent if they want to, any board member. But if they all agree to hear it in consent, then you let the clerk know, the clerk will know, let the parties know. And then only they are submitting the comments to or the rest of the board members and to the public, where they post it.
Well, I think let's do this.
And if I may add, it's more prudent if it's before the hearing. Like, for instance, the case today, there were comments by me, and so I think if it would have been, I think we all got those comments, the hearing board exhibit this morning. I don't think anybody read it, quite frankly, but it would have been maybe nice if it got a few days earlier, everybody could see, oh, okay, those questions were raised and, answered, and we can all vote, make the 6 findings.
Well, I think we will want to discuss this a little bit more. So let's go ahead, unless there's any objections on the others, if anybody
May I
wanted
just
to.
ask a question of a clarification, please?
Okay, let me just finish my sentence first. Okay, so I think that if we go ahead and we vote on the others and we come back to this, because I think there's a lively discussion here that might facilitate the time that we take for, unless there's something else that somebody wanted to bring up on the other issues. Any objections to that?
Do you have a comment
Yes, go ahead.
on that part of it, Ms. Thomas?
Yes, it was just clarification on something that Ms. Conacher-Macklin said regarding the response, when we get the response back to the board member's question on a consent item. So currently, once that's all complete and it's been agreed to put it on the consent calendar, then we make the question and the response from the parties available to the public. And then we also send it to the board members. So are you saying we should not be doing that until?
For board members, it's not a problem for members of the public, it's a problem for board members. You may want to consider just sending one response. If you send a response, then you do run the risk of doing what Mr. Allen suggested, which is for other members to form an opinion based upon what they've heard in the response. So the response should come back. The response can't go to the public, but not come back. But then the board members are going to keep them from seeing public response.
So Madam Chair, so just on this point, what currently happens is as information is moving and transacting through the system, it's being shared. Strike one. Now, our rule states the matters should be posted pursuant to the code, which means all those exhibits, it goes back to this, this is really funny because it goes back to number 4, right? It goes back to number 4. So all those comments ought to be exhibits posted 72 hours prior to, which means no exhibit should be passed to the board during a meeting, to your point, right? So that everyone has an opportunity to review the documentation if it's been posted. But the question is, I'm not for certain. I see the emails coming, but I don't know if they're being posted and shared as exhibits or as addendums to the agenda.
Okay,
Well, just a moment. I normally, as you know, purposely mark those email strings as HB 1, 2, 3, or 4 because I want it on the record that existed, the conversation between whomever's asking the question through the clerk to whatever company. I want that on the record at all times. I don't have to, that I've been told sometimes it doesn't need to be marked as an exhibit. I want it marked as an exhibit because I want, as you're saying, everybody to know that exists. Now, let me tell you what my personal feeling is on that based on how I have sat on the governing board. I choose personally not to look at that until we're here. That's just what I do because I feel that's what I should do. And it does have to do with the Brown Act because of the way that it already is going out to the board members, but I don't read it necessarily. I know that there have been questions that exist, but I don't read it until I come here and we have it before us as an official exhibit. So, Mr. Pearman, were you going to say?
I was going to correct what I said earlier. It seems like I'm correcting myself a couple of times here. In this particular case that I referenced, we actually did get 72 hours or before email, and it got posted, and to all of us saying the matter has been put on consent, and also the comments that were, in this case was what I had questions on and the response. So this were all done pursuant to the Brown Act. It was, it was posted, and all board members got those correspondence, email saying this matter has been put on consent and here are the questions and whatever else board member had, and then a copy was provided in addition this morning to all the board members. So, and I think that has been the, I hate to say the procedure, but it has always been the case. It's not just something that you are doing, Madam Chair, but always been the case where there's a hearing board exhibit. The hearing board creates an exhibit, a board member creates an exhibit that is create an exhibit, then it should be marked and the public should be aware of it.
However, sometimes it's been grouped into something else, and I always try to pull it out because I want it known that a board member legitimately had questions. Ms. Conager-Macklin?
Yes, a couple of things. Number one of the primary focuses of the Brown Act is the meeting itself, whether or not you're having a meeting without the public knowing about it. Not necessarily just the dissemination of information. I agree this can be reworked so that we can resolve some of the concerns that have been raised today, but I don't want to get into a position where we conflate the issues of disseminating information into of having a meeting. They're two different things. And we need to be careful about the dissemination, which will lead to a meeting. And if we're not meeting and not considering it until we're assembled as a body, we resolve that Brown Act concern.
Bingo.
Thank you. Mr. Pearman?
Yeah, and then I think the proposed 7 of new C deals with the issue as raised by Mohan, because basically it says if the decision to pull occurs before the agenda's been posted, that communication will then go to the full board for the first time. And if it's not available till afterward, consistent with the Brown Act, you put it as soon as you can before the meeting occurs. So this directs the clerk's office when and how to do it in a satisfactory fashion.
All right, I just got one other point to that, to Mr. Pearman's, I wanted to respond. So the clerk's office, some of these agendas are posted 10 days pursuant to the Health and Safety Code. They're well out on the street. The consent discussion may take place days, if not a day prior to. So I want to ask a question to the attorney. Can you define what does it mean at any time prior to the submission of the case? What does that mean, comma?
I think that's clear language. It means what you think it means.
Okay, right. So how would you know that the case was submitted unless the matter was posted, right? If the matter's posted, then you know the case was submitted.
So by I guess submitted in this case, I mean when the board takes an action on the case. So if it's on consent calendar, they'd do a consent vote, or if it's not on consent calendar, there'd be hearing, and then at the end of that, it would be submitted. But not until it is actually at a meeting, whether it's on consent or not, would it be submitted.
Okay, so you wouldn't know it's on consent until it's actually on consent.
Well, the process contemplates, that a matter be listed as on consent in the agenda within 72 hours.
Okay, there we go. Now we're talking, because it's typically a day or two before. So there are a host of challenges here for which we ought to correct in order to ensure that there's fluency. Some of these consent matters, you may get the word a few days prior to a day. It's been a day. So it makes it challenging. So perhaps I would say for the sake of time, we truly look at reworking 4 and 5 and come back with some language that we all can agree with. Because that means either it may take the district's legal team more time to work it. But again, there are challenges and issues all the way around, and I'm glad we're having this discussion to be able to unearth this. Thank you.
Thank you, Mr. Ali. Any other comments, Mr. Pearman?
No, when you're ready, like I said, I still would like to make the motion on the rest of them separate
Okay.
from this.
And just to be clear, remember, Ali, when you say 4 and 5, you're talking B4 of Rule 4 and the new proposed BC. Is that correct?
Yes, just for the record, I'm referencing section B, B4, and then B5. And B4,
Or
B5.
do you mean Rule 4C is the new proposed?
Okay, so you're taking 5 out.
No, C is not a subset of 5. C is a subset of Rule 4.
Okay, very well. So then all of this under 4, I want us to be able to rework it, because if we can redirect some language to the district side of the house, if we can then figure out how to get these negotiated 72 hours before. So if a member does pull it, you have that opportunity to be able to have that fluency.
Understood. Thank you.
Thank you. Okay. With that,
Sure, I'd like to make a motion. I point out that as the agenda says, I think the clerk wanted just some confirmation that on the variance petition, we add the request for a timeline. We voted on that before, but it still hasn't gotten in the form. So the
correct.
point of that addition was to make sure that that's clearly done. And so with that, I would move that we adopt the proposed changes to our rules and procedures as set forth in material and discussed today, with the exception of proposed new rule 4C.
Second.
Okay, any discussion on the matter? All right, if not, then let's go ahead and take a vote. Mr. Balagopalan,
Yes.
Mr. Pearman,
Aye.
Dr. Abraham,
Aye.
Mr. Ali.
Aye.
And I also vote aye, so it's unanimous. Okay, so do we have any public comment? Other than what we've discussed here?
So I just wanted to go back to 4C for a moment. Are we're going to bring, it's going to come back? Is that what the intention is for reworking?
That's everyone's
Oh.
pleasure. I would vote on it today, but it's up to you.
Yeah, that's why I think we can, I don't know, why we cannot vote on it. If you object to it, then,
Well, I think,
But if I object.
but I think there's
so
an
hold on, I
opportunity
wanna go
here.
back to your minority point. I'm the minority. point.
okay,
See, so you can't have it all ways.
right.
You can't have it all ways. You guys can't want to fast track, but then want to come back and you want to be conciliatory and amenable on other points. If the board is considering to vote forward, you guys can more than welcome to proceed forward. I'll vote no. But let's not ever hear the argument again about a minority member having a concern and we want to appease the minority. My concerns are to protect the interests of the hearing board and the integrity with respect to the Brown Act. Bottom line, I want to place that on the record. I'm very clear with respect to that. If the board desires to proceed forward, be my guest.
My
I think my
Okay,
ad
wait a
is,
minute,
if you're going to
wait,
bring
wait,
it back,
Mr.
that's fine. Let's
Balakopan.
just state
Mr.
on the
Balakopan.
record that we're going to do that. That's all.
Mr. Balakopan, just hang on there. My understanding is that we're going to be asking Ms. Conager Macklin again and Dale also, Mr. Larson, to take a look at this, rework this is my understanding here. And I think it behooves us to do that and come out with some language that takes into account all of the comments that have been made by all of the board members here. That's that's what I would like to see. So if I need to make a motion on that separately, okay, so I'd like to make a motion that we direct Ms. Conager Macklin and Mr. Larson to rework 4 as well as 4C, 5C, and that they come back with some language in reference to the comments that have been made here today. Do I have a second?
Second.
Thank you. All right, any comments on the motion?
I'm just going to add, I think the one point that Mr. Ali brought up that I'll agree with is we do get requests for consent the very last minute, like the day, and we have to rush it through. And maybe we should look at putting, it might delay, but at least the 72 hours so that it can be posted like he's pointed out. Because we do get quite often, actually, recently, last minute requests for consent. A day off like he indicated. So I think that's a well stated point. If we're going to require it to be posted and so forth, then it should be, submit the documentation so many days before, and the due date also to reflect that can be posted within, whatever time frame the Brown Act requires, 72 hours.
I think Ms. Conacher-Macklin and Mr. Larson will take all of our comments into account.
I
and
just
come
wanted to
back.
state that, yeah, I agree on that respect with Mr. Ali,
Okay, thank you for that. All right, so we haven't voted on that, so,
Oh, I would, yes.
okay, thank you, Mr. Perry.
Aye.
Dr. Abraham.
Aye.
Mr. Ali.
Aye.
And I also vote aye, so that's unanimous. So we will direct you to go ahead and rework that for us and come back to us at your earliest convenience. And I don't think that we have any,
There's one more motion.
one more. Go ahead.
So the second thing is, as discussed, October 18th presentation, some of the rules we want require the actual governing board procedures in regs 8, Roman numeral 8 and Roman numeral 5 to be changed. Again, we can't direct that, we can only request. So I would move that the hearing board agree that working with my input in the chair, director a letter or a document in the appropriate fashion to the AQMD hearing board to make appropriate company changes to those regulations as affect the internal rules and regulations changes we've adopted today.
You mean the
Second.
governing board?
Yes.
Ali seconds.
Okay, any discussion on the motion? All right, Mr. Balagopalan,
I would, yes.
Mr. Pearman?
Yes.
Dr. Abraham?
Aye.
Mr. Ali?
Aye.
And I also vote aye. Okay, I think that takes care of everything. All right, thank you very much. Unless there's any other comments, we thank you for attending, and especially our illustrious Mr. Larson, our attorney there, and our alternates, Ms. Conacher-Macklin and Mr. Samaniego. So thank you very much. Thank you, board members, for hanging in there until 11 o'clock.
Excuse me, Madam Chair, I'd also
Yes.
like to introduce the alternate medical member. She's sitting in the
Oh, I'm
back
so
there.
sorry. I didn't even see you back there.
Dr. Sharon Williams.
Thank you. Thank you for appearing. Thank you, Catherine. Okay. So we are adjourned. Thank you very much, board members.